Mr. Carlson, this is Nathan Hartshorn at the Minnesota Attorney General's office. My clients, Mark Ritchie and Mark Black, have filed a motion to strike your response memorandum on the motion to dismiss in Ritchie versus Carlson in Minnesota Federal District Court.
Pursuant to Local Rule 6.1 Continuance, Plaintiff Stephen W. Carlson hereby moves, for good cause shown, that 1. This Court continue the proceedings until such time as the Minnesota Supreme Court can hear, consider, and decide the Minnesota Statutes 204B.44 election petition and 209.21 congressional elections contest pending there. 2. The Court extend the time for filing of plaintiff's response to the motion to dismiss of respondents and accept that response under the application of the local rules in this instance based on the fact that plaintiff did not have and was not provided with actual notice of the July 23, 2012 changes in the local rule 7.1, and that the state's motion to dismiss and motion to strike were also filed in violation of the new local rule 7.1, and 3, continue the briefing, hearing, and determination of the state's motion to dismiss until a pretrial conference with the magistrate considers the posture of the case after the Minnesota Supreme Court deals with its petition and contest, and 4, to strike all the state's references from the case to extraneous litigation, including the employment case which Judge Davis presided over, as inappropriate and prejudicial. This motion is brought pursuant to Local Rules 6.1, 7.1, and 1.3 for the good cause as follows, and in consideration of Federal Rules of Civil Procedure 7, the Rules Enabling Act, and Federal Rules of Civil Procedure 1 and 83, the First and Fifth Amendments, due process, access to the courts, and the core First Amendment rights being litigated in the instant suit, on the grounds that A, since the case was commenced and the order for pretrial conference was filed, there have been commenced state proceedings, Minnesota Supreme Court A12 2286, constituting a pending intervening proceeding requiring a continuance in this case and a temporary abstention by the federal court pending the outcome of the state adjudication of the matter, especially where, in the state case, the state's testimony is greatly at odds on material issues like the reasons of Secretary Ritchie for refusing during the heat of the election to release to plaintiff the email addresses collected by the state for political and election purposes. The court's disposition of the case before it should be based on both the state determinations and a full and fair presentation of the case through a deliberative process to be established at the planned pretrial conference. While the state's attorney has attempted to file a motion to dismiss and a motion to strike plaintiff's response, he has not followed the local rules himself, introducing great irregularity into the proceedings. And this irregularity should not be allowed and should be remedied in a pretrial conference with the magistrate following the determination of the state claims. The instant lawsuit includes important constitutional questions which have not been addressed by the court and need to be, and these constitutional questions do not rest on procedure, and should the court take any adverse action based on the filing of plaintiff's response to the motion to dismiss, that would constitute an adverse consequence and loss of rights, contravening the purpose of the Federal Rules of Civil Procedure and Rules Enabling Act, and their proper construction by the court would counsel a full and fair determination of the plaintiff's claims, including admitting plaintiff's written response to the state's motion to dismiss. The constitutional protection may not be regarded as resting on mere procedural details. Neer v. Minnesota, 283-697 from 1931. Thus, this court must fully address the constitutional protections which are at the heart of the instant case, and for that the court needs the benefit of a continuance, and to satisfy the demands of Fifth Amendment due process requires a full and fair litigation of all these constitutional issues, consistent with the Minnesota constitutional and statutory issues which are invoked in plaintiff's claims. It is improper in a case based on claim of First Amendment rights in a federal election for the state of Minnesota to bring into the case extraneous claims that the plaintiff is a, quote, danger to the federal courts, unquote, and therefore to prejudice the court and the case against the claims without establishing or asserting some connection between those cases and the federal elections. Memorandum of Law. Introduction. Plaintiff Stephen W. Carlson seeks to continue this case regarding the constitutionality of the actions of the state of Minnesota in the 2012 elections, while the related case at the Minnesota Supreme Court is being addressed by the state, and to allow his response and the reply, if any, filed by the state, and to continue the state's motion once the irregularities, see infra, are resolved to protect the parties and the interests of justice, until after a pretrial conference after the Supreme Court concludes its determination in A-12-2286, consisting of a Minnesota Statutes 204B.44 election petition and 209.21 congressional elections contest. Already the interference between these two cases has created an injustice, as the state seeks to misapply local rules to exclude plaintiffs' response to their motion to dismiss, seeking to take away constitutional rights by engaging in technical competition in irregularities which are not allowed by the applicable federal statutes authorizing district courts to establish and apply local rules. This takes away a great deal of plaintiffs' limited time and effort, which should be devoted to the substance of the case in the Minnesota Supreme Court and this case, and this interference is one ground for the continuance. Even if there were no irregularities and improper attempts to strike, however, the court should continue the case because the selection of representatives to the U.S. Congress is committed by the U.S. Constitution to the states, and Minnesota in the Supreme Court should have the opportunity to enforce its own laws consistent with the U.S. Constitution and statutes, with the outcome in that case influencing the appropriate disposition of this case. The Minnesota Supreme Court can make factual determinations and can instruct election officials on their conduct in this and future elections, and can forward their factual determinations to the U.S. House of Representatives for that body's disposition of the election contest against Representative McCollum. What remains for this court to decide is the constitutionality of the actions of defendants in this case. This will avoid unnecessary and unwanted duplication, as well as reducing the interference and irregularities caused by the state's motion to dismiss. The only way the court can remedy the irregularities of the state and also eliminate the improper interference with the litigation of these claims on their just merits is to extend the time for filing under the local rules to accept the response to the motion to dismiss. Secretary Ritchie's and Burt Black's motion to dismiss. The state of Minnesota, responding to the constitutional claims presented to this court during the 2012 general election for a congressional seat during the last days before the November 6th election date, in which plaintiffs sought this court's intervention and injunction to force the release of the email addresses of all those registered voters in the Congressional District 4, so I could send emails to those voters telling them about my positions and qualifications in the congressional election and seek their vote, has presented a number of defenses in their motion to dismiss, and then has sought to impose the adverse consequence and loss of rights on plaintiff and his claims of striking my response to the motion for the record. But plaintiff was not provided with actual notice and had no actual notice of the July 23, 2012 change in Local Rule 7.1, a matter of form, which changed the time for filing a response to a motion to dismiss from 21 days before the scheduled hearing to 21 days after the motion papers were filed. Mr. Hartshorn and defendants are also in the state case, so they knew of the requirements for the filing of the petition and the 209.21 election contest for congressional elections, which they attempted to block in the Ramsey County District Court, then went ahead and forwarded Representative McCollum's name to Congress December 10th, 5 days after all the other Minnesota districts were sent, despite the fact they knew the election contest had been properly served and filed on December 4th. Further, as the U.S. Supreme Court said to Minnesota in Neer v. Minnesota, 1931, quote, "The constitutional protection of the First Amendment may not be regarded as resting on mere procedural details, But here, as in Neer, the state is once again trying to avoid constitutional protections in its conduct of elections for federal office by saying those protections are only available if plaintiff follows the niceties of local rules and directives, even though the Enabling Act and the Federal Rules of Civil Procedure 1 and 83 counsel against this misapplication of technical matters of form. To comply with the mandate of Neer, this court must look to the record as a whole, including the written response to the motion to dismiss, to make sure these allegedly unconstitutional election practices of the state give the constitutional protections secured by the U.S. Constitution in the First Amendment, freedoms of assembly, association, and political expression, and the 14th and the 15th Amendment, barring discrimination in voting and participation based on race, and the 19th Amendment, barring discrimination in voting and participation based on sex. And since the election of congressional officers is given to the states by the U.S. Constitution, the election provisions of the Minnesota Constitution must be taken into account and deferred to by this court, insofar as they comport with the U.S. Constitution. Those provisions raised in the state case include Article 1, Bill of Rights, Section 1, Object of Government, Article 1, Bill of Rights, Section 2, Rights and Privileges, and Article 7, Elective Franchise, Section 1, Eligibility, Place of Voting, and Ineligible Persons. Further, by the U.S. Constitution, the selection of representatives for Congress is left with the states, Article 1, Section 2 and 4. Although their conduct of those elections is also regulated by the U.S. Constitution, here the 1st, 14th, 15th, and 19th Amendments, and federal laws. Although the state has attempted to bring before the court a motion to strike, which also did not comply with Local Rule 7.1, the exclusion of plaintiff's response to the motion to dismiss would violate the First and Fifth Amendments' access to the federal courts and due process, as well as the Federal Rules of Civil Procedure Rule 7, Local Rule 1.3, Federal Rules of Civil Procedure Rules 83 and 1, and 28 U.S.C. 2071 and 2072, the Rules Enabling Act. Requirements of form in the district court may not be used to take away any procedural or substantive right. What the district court has changed in 2012, that is to say, whether the response needs to be filed 21 days after the motion papers or 21 days before the hearing, as the previous rule read, is a matter of form. By treating this instance as an occasion for the court to impose any remedy whatsoever, the state invites the adverse consequence of striking a written response to a dispositive motion, and even greater loss of rights and adverse consequences listed in the court's local rules themselves. Thus, this is a strong reason barring the application of this new rule as is asked by the state. Federal Rule of Civil Procedure 83 provides 2. Requirement of form. A local rule imposing a requirement of form must not be enforced in a way that causes a party to lose any right because of a non-willful failure to comply. If actual notice is not given or shown, any failure to comply is non-willful. The note to this rule explains why no adverse consequence or loss of rights should follow from the violations asserted by the state. Paragraph 2 is new. Its aim is to protect against loss of rights in the enforcement of local rules relating to matters of form. For example, a party should not be deprived of a right to a jury trial because its attorney, unaware of or forgetting a local rule directing that jury demands be noted in the caption of the case, includes a jury demand only in the body of the pleading. The proscription of paragraph 2 is narrowly drawn, covering only violations attributable to non-willful failure to comply, and only those involving local rules directed to matters of form. It does not limit the court's power to impose substantive penalties upon a party if it or its attorney contumaciously or willfully violates a local rule, even one involving merely a matter of form. Nor does it affect the court's power to enforce local rules that involve more than mere matters of form. For example, a local rule requiring parties to identify evidentiary matters relied upon to support or oppose motions for summary judgment. In this case, plaintiff simply asks that the court consider the merits of the written response to the motion to dismiss. Should that written response be inadequate, substantive penalties, including dismissal, would in no way be barred by the court's local rules. For example, plaintiff would not be allowed to supply more matters in opposition to the motion to dismiss in written form. But the particular time the response was filed, 21 days before the hearing, is merely a matter of form, not of the substance of the response. Adverse consequences to plaintiff are barred by the Federal Rules of Civil Procedure in this case. I had no actual notice of the change in this local rule July 23, 2012, until I was contacted by Mr. Hartshorn. The court may read the 1995 notes to the Federal Rules of Civil Procedure, Rule 83. This federal rule grants to this court the power to make and enforce its local rules. It is governed by Rule 1's charge that, quote, it should be construed and administered to secure the just, speedy, and inexpensive determination of every action and proceeding. To see how the actual notice of a change in the local rules can be accomplished, quote, furnishing litigants with a copy outlining the judge's practices, or attaching instructions to a notice setting a case for conference or trial, would suffice to give actual notice, as would an order in a case specifically adopting by reference a judge's standing order and indicating how copies can be obtained. The advisory committee's reasoning is set forth in the notes as follows. Quote, this rule recognizes that courts rely on multiple directives to control practice. Some courts regulate practice through the published federal rules and the local rules of the court. Some courts also have used internal operating procedures, standing orders, and other internal directives. Although such directives continue to be authorized, they can lead to problems. Counsel or litigants may be unaware of various directives. In addition, the sheer volume of directives may impose an unreasonable barrier. For example, it may be difficult to obtain copies of the directives. Finally, counsel or litigants may be unfairly sanctioned for failing to comply with the directive. For these reasons, the amendment to this rule disapproves imposing any sanction or other disadvantage on a person for noncompliance with such an internal directive, unless the alleged violator has been furnished actual notice of the requirement in a particular case. There should be no adverse consequence to a party or attorney for violating special requirements relating to practice before a particular court, unless the party or attorney has actual notice of those requirements. The state has made no showing that such actual notice of the change in the directives of this particular court was provided to me, and it was not. Striking my response to the motion to dismiss, as the state of Minnesota wishes to do to advance their prospects of defending unconstitutional conduct of federal officer elections, is an adverse consequence and loss of rights prohibited by the federal rule.